Hey, long.
Yeah, that's the thing. You spend all day talking about real estate, and then in your time off, come online and talk more work, talk more shop.
Well, let's start it out this way. How's your golf game, Scott?
In 105-degree weather, it sucks. How is yours out there in 118? No.
Ah, man, I'm in Wisconsin right now. It's
Are you
about
really?
74 degrees and overcast.
How'd you get the same
I
backdrop
actually
set
am
up?
up in it travels.
Okay.
We've
I've
thought through
done,
this.
Yeah, I've done this out of hotel rooms and all kinds of stuff. I basically haven't been home to my house in Chandler, Arizona since like March 15th. I've gone home for a week here or there, but my family's been traveling, and now we're up here living in Wisconsin, near. I don't know if you're familiar with it, Scott, but Whistling Straits, where the Ryder Cup was a few years back. We're just down the road from Whistling Straits.
Cool. I'm hoping to get a chance to go to Italy if I can get my wife to do a few things, where we'll go to the Ryder Cup there as well this year.
Oh, that'd be nice.
Yeah,
We'll
that'd
see.
be awesome. Yeah,
I just want to have the
that'll
weather
be cool.
you got.
I made it up here.
So what are you from,
What?
Wisconsin?
My wife has some family here, and we kind of discovered it during COVID. And I came back here for the Ryder Cup, and we've come back and forth. And finally, we just decided, hey, that's where we want to be for a while. So we're up here in Wisconsin.
Whoa. Are you moving from Arizona
not
to
too far from Lake Michigan?
So you're moving from Arizona to Michigan?
I wouldn't say I'm moving, but we're here through the summer. Let's just put it that way.
Okay.
Kind
I
of
don't
like how I'm
blame
in
you.
Florida for the winter.
And then
Kind of like how
hopefully-
I'm in Florida for the winter. Yeah.
Yeah.
Hey, Andy, I'd ask for a
Yeah,
raise.
that's exactly right.
Well, I'm going to send you. You do employment law, right, Scott? I'll hire you, and you can negotiate this deal because
I do zero employment law, baby. I think that I can't imagine one of the things too much worse than that.
Yeah, that's a tough one. If you're watching right now, you're watching The Collective. We just went live a few minutes ago, and we're getting together, lawyers talking about creative finance and other sundry items, including important things like golf and second homes and places to stay away from the places that are hot. But if you have any questions, the important thing is ask them. We're here and available for the hour or the time that we're here to answer any questions regarding creative finance that you might have. Sean, I know I cut you off. I don't know if you were mid-sentence on something.
No, but I do want to bring something up and kind of get these guys' take. One of the things that I've kind of been thinking about or pondering, and you guys, I could be way off base, but with the inflation that we've had and the uptick in interest rates, obviously, at least here in Arizona, maybe a few communities are exception, but for the most part, we've not seen any dip in prices. In fact, we've seen, continued appreciation in the Arizona market. And even here in Wisconsin, we're seeing appreciation. And, I think, well, how is that? Why haven't we seen the dip with what's going on? And I think, honestly, it's a lack of supply with the low interest rates, that are out there. But a buddy of mine who does commercial lending work at a big firm in Phoenix, I was talking to him the other day, and one of the things that is out there is on the commercial side of things, you have loans that are much shorter, right? And commercial, you don't lend for 30 years. You maybe lend for 5 years, or construction loans are going to be less than that, or maybe 10 years. So you have a bunch of these, loans coming due in the commercial space where I'm not sure people can refinance out of it. What are your thoughts? Where do you think commercial real estate may go, and what are the opportunities out there?
Well, I mean, I'm not sure about you guys, but I've talked to a couple of commercial guys here local who have all had the same comment, it seems like, wherein, the loans are coming due and of course the rates are substantially higher and they are renewing and extending. It's just that they're having to come to the table with a wad of cash because the numbers just don't work. And so the lenders are requiring, there has to be a large principal reduction to get it down to the proper levels. It won't support the income. So things are just changing is what I'm seeing out there. And I'll tell you that with my banks also, I have all of these loans in my books at 4, 5, 6% interest rates. And as they're renewing and extending, because they were fixed for 5 years, and now they're renewing and extending, and they're 8.5, 9. Hell, one of them's 9.5. And so, of course, I'm working on moving all those over to another venue of mine where we can refinance them out at maybe 7.75 or 8%. That's better than 9.25 or 9.5. And what's funny, guys, is we all may have been doing this, by the way, preaching to the choir out there about rates. And, you go back to 2012, 13, 14, rates were so, unbelievably low, and they kept maintaining there. And for those of us who've been around for a while, we're all going, they've got to go up. They have to go up. It can't stay this low. And they don't. And then you keep telling your audiences and your investors, like, guys, you can't plan on this low rate forever. It will change. And of course, no one thought it was going to change this fast and go up that much, but it did, right? So at least in the commercial world as well, that's happening to them. And they're having to adjust, and hopefully they got funds set aside or the access to funds to adjust accordingly.
Interesting.
Let me chime in with what I'm seeing in Northeast Ohio. I've seen banks pull deals involving commercial office space. They've just walked away. They said, no, we won't fund the deal. As far as residential multifamily, they're still looking at doing deals. That area is the strongest of all the commercial space out there. The multifamily is the strongest that I'm seeing. Office space is weak and getting weaker for a whole host of reasons. And I think if you're going to go forward in this business, you have to stress test going into a deal. You've got to stress test. You've got to run the numbers and say, at what point can we still break even or make money, interest rate rise, and how much more do we really think we can get rent increase wise? And the other two issues that are out there, and this is affecting commercial, this is affecting residential, is the county-wide blanket massive tax increases that we're seeing. One county in Northeast Ohio, just across the board, 29% up on everything. And those hurt.
Yeah. What they did here in Dallas, Jeff, is they got smart regarding property taxes. So instead of adjusting the taxes on the structure, they went across and just laid in a value for the land. What used to be the land value maybe at $80,000 a year or two ago, blanket the entire neighborhood $200,000. And so how do you argue that they don't adjust the structure cost? Because that's very arguable as to condition and things of that nature. But how do you argue the land pricing changes?
And that's, Scott, that's incredibly hard to do. I mean, from a taxing standpoint, it was a smart.
No.
Doesn't develop a roof leak,
Yeah.
Yeah.
For a minute there, Jeff, I was going to give you a nickname of Shotgun Willie, since your picture had been blanked out for a bit. And do you know the song at all?
The song Shotgun
No,
Willie?
Yeah. You know, so Shotgun Willie sits around in his underwear. You'll have to look it up.
I know this
It's an
song.
older C&W song.
I'm gonna blank.
Uh-oh.
The pic.
Yeah. Yeah, Jeff, I think you're having trouble with your connection. You know, Scott, I almost wonder if Shotgun Willie sounds like a song that would have been written during Zoom meetings in the time of COVID. I mean, isn't that basically how everybody was appearing?
Well, it may have been, you know, but I think that predates COVID by
a little
many,
bit.
many years. I'm sitting here looking it up as we're talking, by the way. Sorry for the version.
So what, you know, speaking of commercial loans and commercial lendings and the trouble that it's facing, since we're talking about creative finance deals and creative finance transactions, what kind of conditions would you need to see to be comfortable doing a creative finance deal on a commercial transaction, assuming you could?
You know, I haven't done a lot of commercial stuff lately. You know, we're almost exclusively residential. We do some, but you know, we do see some acquisition from a creative perspective, whether it's a subject to transaction, for lack of a better word, or whether it's a wrap where the terms might be more reasonable, or where the borrower, or excuse me, the seller is debt free in the property. I just think it gets to be very problematic that when these rates crank up on these shorter term loans, like, you know, for instance, my banking loans are 5-year notes, 15-year AMs typically. They're not 30-year loans. But from the commercial perspective, if they still got the lower rates, that's great. No, maybe they did get a long-term FHA type loan, the commercial transaction that they can, you know, either maintain easier or can be sold easier in that format. But, you know, as Jeff was saying, when these rates go up, the taxes go up, it changes all the dynamics on your net operating income and the requirements your lender has. And, you know, it makes you wonder if you get back into a scenario like it was back in the RTC days. I don't know if you guys, I was very young back then. You know, I just knew the name RTC and you kind of had a flavor of what was going on, but you really didn't know what was going on until you look back in hindsight. And I mean, it's like, holy cow. And could the lenders just blanket start calling these loans due? I don't think they want to do that, but they could. And I just think we've kind of moved into a little bit of a spooky territory right now.
Jeff, if you can hear us, you mentioned you're doing or working on sub 2 commercial deals. Can you explain those?
I will be happy to dig into it a lot more once it's closed.
Okay.
Because it hasn't closed yet, and so I'm involved as both a counsel and as part of the buying unit. So I want to be careful, but it's a creative acquisition of a commercial multifamily property in in Ohio, where with the bank's consent, the buyer is stepping in and taking and guaranteeing on the existing $6 million plus loan at 3.25% interest. And yeah, we're bringing in a lot of cash, but it is the most creative commercial deal I've ever seen.
At least you're getting to know the
bank's.
Yeah, at least you're getting to know the bank's consent, though. That's the positive.
Yeah.
And
that's
obviously they
Well,
want.
Well, that brings up a good point, and I'm curious if you guys have the same case law in Ohio and Texas. But so back in the early 80s, before the Garn St. Germain, Arizona and our Supreme Court, there was a line of case authority that basically said that a due on sale clause would be a restraint on alienation unless the lender could prove that its security was jeopardized as a result of the transfer, meaning for some reason you're not in the same position, first position, second position, and that the subsequent buyer is not as good of a credit risk as the prior seller. And so our Supreme Court would refuse to enforce the due on sale clause as written, and instead made the lender show that if it was transferred without the lender's consent, they have to show that their security was, jeopardized. And so, of course, Garden St. Germain, as far as residential property goes and federally insured loans go, they wipe that out. But that line of authority, we even have cases subsequent to Garden St. Germain that confirms rule on commercial. That's not the same. That that authority still stands on commercial property and commercial loans. Do you guys have that in Texas or Ohio?
I don't know about that in Texas, but you know what I'm going to do first thing in the morning? I'm going to my litigation
You're going to
boys
research
and
it.
have them, research that real quick and shepherdize it and go, okay, what's out there? Because, by the way, what you just said, Sean, is common sense, right?
Yeah.
What I find so interesting when you get to due on sale. So, for instance, when I do a deal with one of my banks know exactly what I do, how I do it, full disclosure, and I have permission to do my wraparound, so I don't get a due on sale. And what I have found is the reason why is they understand that they already have me on the hook, corporately guaranteed, personally guaranteed. So if I sell the house to another party, they know that they have a secondary source of repayment. They're still in first lien position, easy. They still have the collateral backup through me, easy. Now they have a secondary source. They get it. When you talk to a mortgage company, oh my gosh, it is like talking to a blank wall. Years ago, I did a deal, I don't know what it was, and the mortgage company had done a loan for a 75-year-old couple who moved out into some type of it wasn't a nursing facility, but just a senior retirement, type scenario. They needed to get out and they needed to sell the house. And this was the best way of doing it. And the lender tried to call the loan due. And I got on the phone and I'm asking them the same basic questions. And it's like they're reading a script, and it's like, why? Tell me what the situation is from y'all's end that you want to call this loan due. Is it not current? Yep. Are you fully insured? Yep. Are you still in first lien position? Yep. Has your collateral base been damaged in any form or fashion? Nope. Don't you now have a secondary source of repayment? Well, and of course it was like no answers. Then I got on the phone with their attorney for this mortgage company. He couldn't answer the questions. And then they started giving me all this guff about the loan and whatnot and maturities. And I'm going, guys, you lent money to a 75-year-old couple that needed to get out of the house into long-term assisted care type arrangements. And oh my goodness. That, by the way, they didn't call the loan due. I don't know why, but it's frustrating. And I love what you just said, Sean. I think it's so wise. I want to find out if that's the case here in Texas or if there's any case law on that, because that to me is absolutely common sense. And I get if you've got a certain property with a certain borrower that you need in there for whatever reason it might be, and you lessen the collateral or the borrower, whatever it might be, so the lender has been impaired in some format. Okay, I understand that. But when it goes their direction, it's ludicrous. Maybe that's why we see so little of this stuff out there. We see some of it, but not a lot.
Yeah.
And maybe that's the case, but I tell you, I don't know if it's because that these lenders have sold off the loans to Wall Street in some packaging, whatever they've done out there. And if there's some written agreement they have in that scenario because of that? I don't know that answer, but I'm absolutely dumbfounded you guys have that in Arizona. I'm hoping it's the same thing here. It'd be awesome. Something to fall back on. And, I may have brought this up one time previously, but here in Texas, I've seen on a couple of occasions a letter from, and I'll use the lender's name, U.S. Bank. So they're headquartered somewhere up north, I think, and a property in Texas where the property owner conveyed the property into a land trust. And we disclosed that to the lender, maybe paid a small fee to get some things changed over for him and took care of that. But then they send out a letter saying, we see that you have transferred your property to your trust. You can't do that. Or they've moved out and they've leased the property. They do the same thing, that you no longer live there. And this is a tax-free loan. And I go, what the hell is a tax-free loan? So you pull up the deed of trust and there's an addendum and a rider to the deed of trust where it's some type of a tax-free mechanism for the lender. Now, it's not tax-free for the borrower. They're still paying their interest. They're paying their property taxes, everything else. And I shot back a letter, and they keep wanting to argue with me. And here in Texas, once you buy a home, you move into it, you live there, you've met your intent purposes and those kind of things.
Mm-hmm.
If you move out and lease the property, that's fine. The lender can't tell you, no, you can't do that. And they're trying to tell you, you cannot move out of the house, period. And we're going, sorry, guys, Texas Constitution doesn't allow that. That's an alienation on property. And you see these funky things like that. And maybe the law where U.S. Bank is located, says they can do that in some format. Or are they just trying to control the deal more? I don't know what it is or what they're doing. But, they try to strong arm these people. And if you don't know better, they may just stay there. I don't know.
Yeah, I think under Garn St. Germain, you can lease a property up to, I think, 3 years or something like that, and not have the due on sale clause revoked. And I think as far as transferring to a trust, as long as you're continue to be the settler, you would be the settler, you're the trustee and beneficiary of the trust, that's not a problem either.
I mean, yeah, they can call it if there's a transfer of the beneficial interest and those kind of things, but it's just the things
Correct.
These lenders do, and there is no common sense to it at all. I get if the collateral's been diminished in some format, whether it's from the borrower's perspective
Right.
or the property itself, that's common sense. But as to something else, when they're still fully protected as if they'd be in any other format, if their borrower's facing bankruptcy or foreclosure and a third party steps in who's in much better financial condition, you'd think they'd just say thank you and move on. But I don't get it. I'll tell you a quick story, guys. This goes back to 2010, where I had financed 40 or 50 properties with a California lender back then. Or actually, I did these loans back in 2000 and probably in 2000. I did this large package of refinances with what was then Home Savings. Home Savings became something else, and eventually all these lenders went down, and I think Wells Fargo and Chase took over most of the stuff. But in the beginning, we did all these loans, put them into our limited partnership. The lenders knew exactly what we were going to do, and we had them all sold. And in 2010, so of course, real estate crash just hit. There are hundreds and hundreds of thousands of mortgages in default. So here's this loan. It's at a 40% loan to value, probably, or less. There's a perfect pay history along the way. And I transfer it into a family limited partnership. I get a due on sale clause. And I was so furious that these lenders, this was Wells Fargo. They have hundreds of thousands of loans in default they're doing nothing with. But yet here's a loan that is in full compliance. We just transferred it. And they're trying to call the loan due. I was that close to calling my congressman and just raising holy hell about it. It was just incredulous. And the poor young lawyer here in Dallas I was talking to, I just berated her. I probably shouldn't have done that. I was just incensed. But it was just like, you got to be kidding me. And I don't remember what all I may have just paid it off and went on down the line, but you see these kind of things and zero common sense. None.
Speaking of
Go ahead, Sean.
Jeff, were you going to chime in?
No, that was me. Go ahead.
Oh, speaking of Congress, and I don't know, Jeff, if your internet's working any better or whatnot, but I know you are tracking a number of pieces of legislation that are, both good and bad for investors. You want to talk to us about the latest and greatest on some of that stuff? His internet might
not be doing well. He doesn't seem to be coming through.
No.
Here's an interesting thing while we wait for Jeff. By the way, if you're just watching us, this is the Creative Finance Collective. We're talking about all things creative finance. So if you have questions, make sure to put them in there, and we'll do our best to answer that. You can put your question right in the chat. Scott, last week we talked a little bit about the hype, the longevity of creative finance, maybe some of the economic conditions that put us where we're at. And I thought this was interesting. But I was reading an article, and I haven't checked the veracity of this information, but what it claimed in terms of trying to explain supply in this, we're not talking commercial anymore, but the residential housing market, and explaining supply and why likely supply is going to stay tight the way that it is. The numbers were 25% of outstanding mortgages are at or below 3%. 65% of outstanding mortgages are at or below 4%. And then they claim 42% of all homes have no mortgage at all. In other words, there's a huge amount of either homes that don't have a mortgage or tons of homes that have a mortgage that are at or below 4%. Many at or below 3%. And it doesn't take a rocket science to understand why a homeowner isn't going to want to go sell their home only to jump into a more expensive place with a much higher interest rate. It would suggest that, this of course might explain why prices haven't plummeted and they've stayed where they are because supply stays tight. But with these kind of conditions for the foreseeable future, it doesn't seem like the strategy of creative finance is going anywhere.
No. And by the way, I agree with you. And with the economy where it is, what we're still seeing out there is a plethora of homeowners who are in trouble. They've lost their job, undersecured, whatever it might be. Forbearances are coming due, whatever things of this nature. They're behind in their payments, on and on and on. And regardless of the reason, whether it's divorce, medical, transfer, I've been talking to a realtor down in San Antonio today, where a lot of these vets got these great VA loans, 0 down, 2.5% interest rates, 3%, 4%. But either they retire and need to move, they retire, need to downsize, they get transferred, and they got to get out. Well, the problem is if they bought the house at 0 down, out of pocket, you're automatically 7, 8, 9% upside down before anything even happens, just with closing costs alone. And of course, we were talking through solutions to that problem, how to address it, how to handle it appropriately. But then you come into those kind of situations where these people, they get transferred, they have to move, and they get house number 2, and they just stop paying house number 1. So it starts to accumulate arrearages.
Mhm.
And so from the investor perspective, it's not just walking in to take over an existing loan that's current, kind of like happened a lot back in 2009 and 10 and 11. But we have arrearages now. So the homeowner, the investor, whoever it might be, who's trying to buy that home, is having to come to the table, of course, realtor fees, arrearages, maybe some cash to the seller. So it's not just that easy to take over that low loan. They need cash to do that with. And are they willing to put that in there? And, a lot of the investors in the marketplace don't have that. So of course they play the game to put the property under contract with the hope to find that end buyer or end investor who does have the cash to do that. And if they're not successful doing it, of course, they just walk away to the seller's detriment. And so you're trying to teach the realtors how to vet this a little bit better, require them to get, non-refundable earnest money that's substantial, so that if they're going to play that game, hold their feet to the fire to protect the seller in some format. But I think in your same verse, Andy, it's not going away anytime soon. And until rates relax, prices come down on real estate, which ain't going to happen, or you're able to get back to that 12% interest rate to a homeowner, which you might be able to do in Arizona because of lower taxes. You can't come close to that in Texas hardly, unless you're in the hood. That I think the creative finance marketplace is just going to grow and grow.
It's really interesting. Sean and I were just talking about this, but oftentimes we've been talking about the commercial real estate market. We just had a guest on our show that does a lot of multifamily investing, and she believed that a reckoning was coming in that space. But oftentimes in economic downturns involving real estate, it's the residential market that leads and the commercial market that lags behind it. And then in turn, when the residential market comes back, the commercial market lags behind that, and it's just kind of following it. It almost feels like it's setting the table for a reverse scenario where it's because of where we're at with what interest rates used to be, that the commercial market goes first or is more problematic. The impact that might have on the residential borrowers, maybe the more loss of jobs because companies are having problems with commercial space or whatever the case may be. But I guess my point in all that, what's kind of interesting is what would usually follow kind of something like that you would expect would be a price or a real severe drop in the price of residential real estate. I'm not sure that's going to be the case if the conditions stay the same. And what you effectively have happening in that kind of scenario is distressed buyers losing their home or but not having anywhere to eventually go or get back in because the prices don't drop. It'll be interesting to see what kind of scenario plays out that way, but things feel very backwards compared to how they've been in the past.
I don't disagree with that, and it's just unique. And I think if you want to look at the investor world for a moment, the investors have to change their thought process, because, for instance, I think I made this comment last time that in today's banking world, that if you want to buy, to compare apples to apples, an 80% loan a year ago is the same today as about a 68% loan to value, which means you got to be able to buy that property 10 to 12% below what you used to buy it at. And we're not there yet, unless you get doggone lucky, which curtails I think the investor scenario from a cash issue, unless the investor has one goal only, which is to fix and flip the property. You're stuck doing that. The buy and hold scenarios go out the window because you can't get the financing in place to make it feasible. So you have to change your approach, your thought process, and what type of transactions you're going to look for, and you wind up in the creative finance world all of a sudden. Whether it's buying debt-free properties or learning how to buy it subject to the right way. But the other thing I see is, as I said earlier, most deals require a reasonable amount of cash to come to the table. And most investors don't have that, so they have to go borrow it. But the problem is, if they do that, because there's limited equity, they're making no profit, because they've got to pay off that private loan in 12 months, 24, 36, 48, whatever it might be. And most of the investors need cash today, not cash tomorrow. And maybe for more seasoned guys like us, that's more of an opportunity. I don't know. But you just watch the dynamics going on out there, and it's interesting. And you're having to change and morph things along the way, just based on the economic issues that are driving things. And it's the same thing as we talked about earlier in the commercial world. Same economic conditions are driving that. So it's taking more brain power, dadgummit, to make these things work. And you got to play lawyer half the time, you got to play investor half the time. The brain power, your head just wants to explode over here, it seems like.
Mm-hmm.
But I want to bring something up to you boys. I'm curious, what are the usury laws in Arizona?
So Arizona is once again the wild, wild west. And if a debt does not contain an interest rate, the court is allowed to imply an interest rate up to 10%. But if there's a contract and the parties have written and agreed to an interest rate that exceeds that amount, they can contract for whatever they want. There is no limit on the amount of interest.
Unlimited?
As long as you have it unlimited, as long as you have it written into the contract. Yeah.
Wow. So here in Texas, it's pretty much 18% for an individual and 24% for a corporate entity on an annualized basis. So let me tell you why I bring that up. Because 6-8 times now in the last 60, 75 days, this has crossed my desk, which I haven't seen for years. And what I'm seeing is in the creative finance world, everybody wants to be a lender. And they have all these new funky names. I'm not going to throw the names out there because it gives a lot of stuff away, I think. But, people will lend an investor earnest money. I'm going, you need to borrow earnest money? If you need to borrow earnest money, should you really be playing the investor game? No, how are you going to make your payments? So that's the first thing. And they charge them 50% of that amount for 30 days. So here in Texas, that's usury. Then I'm seeing investors come in. I saw one do a 3-week loan for 30% flat fee. Wound up being like 138% interest rate. So again, major usury in Texas. And then I'm seeing all of these lenders make loans to other investors for, let's say, 90-day loans. And I'm going, how are they going to repay their loan in 90 days? And they put on a 20% flat fee. Now, it sounds like that might work in Arizona, but in Texas, Absolutely not. And I'm seeing I'm wondering where this information is coming from, and how investor one is telling investor two is telling investor three about this, and whether they're in different states where maybe it's viable in state one, but maybe not viable here in Texas, or maybe a little bit different someplace else. And I look at this, I'm just going, holy cow, guys. Did you ever ask, and by the way, no one has talked to an attorney, not one time, to see how to lend it, how to do a lending agreement, what to do, how to do it. And then they're putting these $1,000 fees on for non-compliance if the loan goes past maturity every 2 weeks. Again, can't do that here in Texas. And I'm just going, it's getting problematic, because I don't think that's just one or two. I've only heard the tip of the iceberg, I think. But you're telling me that
so
Arizona, you guys are good?
Yeah, you are. Obviously, there's still the rule on unconscionability, right? And public policy and those types of things, but that's a very subjective thing. And a trier of fact would have to determine that, right? You're not going to win that on any type of motion for summary judgment.
Well, I think we need to go talk to Mr. Trump about that, right? And all the.
Yeah, exactly. Let me ask you, Scott, though, you bring up a good point on the usury stuff. I'm curious if, let's say, an investor comes to me and they say, hey, I'm doing a deal in Texas. I need to borrow some money, to make the deal happen. Maybe it's a double close. And, so I'm like, yeah, tell you what, let's do that. I'll make you the loan, but I get X percentage of the deal. And we do some type of partnership agreement, joint venture agreement, or whatever. So I'm not charging actual interest. I'm just charging a percentage of the deal. And, if the deal is, $10, I get my whatever percentage. If the deal's 100,000, I get my percentage. Like, there's no set amount or percentage on the thing. But if you do well on this thing, and which is why I'm loaning you the money, because I think you're going to do well, and I get part of the upside, is that going to create usury issues?
No, I think that's how you get around usury. So, people come to me all the time with these kind of scenarios, and they're going, well, how do we structure this deal? And it's like, okay, look. So first off, you probably need to create a corporate entity. I'm not a fan of a JV agreement, because too much can go awry with that. And I'll give you guys an example of that here in the DFW area. But, I suggest first off, form an LLC together, have the investor, number two, the lender, make a loan to the LLC and charge an interest rate. Okay, there's no problem with that. Now that the investor is actually an owner of the property as well, as you just said, Sean, can they collect a percentage of net proceeds as an owner? I think the answer is absolutely yes, you can. And
right.
That becomes totally different than a loan to the property. It could be construed to be the same thing, only different, but it is different, because you're an actual owner of the property now, where you may have to deal with profits and losses and who knows what else. And I think in those situations, you're okay doing that. It's when you cross that line as a lender only, and then there are these other people who are charging fees to marry investor and lender together. I'm going, guys, that's going to be part of the loan costs. And you're not a licensed RMLO or a licensed lender to collect those per se, maybe. And everyone what I see, guys, is I see the marketplace out there, and I find it really interesting about Arizona. And I thought Texas was the Wild West. Texas was founded by thieves and robbers, and Florida was founded by the pirates. And, I'm not sure what's worse, but That's Arizona, I guess, right? Whatever is.
Man, we are, agreements for sale, contracts for deed, lease options. You can do it all.
Yeah,
with your
and I
stuff.
think some of that
I'm
is.
jealous.
I think a lot of that. I think a lot of that is our statehood isn't as old
Yeah.
as the Californias, the Texas, the Floridas, all the rest of them. It's just newer, and we just haven't gotten around to it yet.
Yeah.
I mean, state 48, right? I mean, only we're Ohio and not Ohio, Hawaii and Alaska are newer.
Yeah.
Really? So hold it. I didn't know. I should have known my history a little bit better there, but wow, is all I can say. And I keep trying to tell these investors, it's just like, guys, you've got to find out what the rules and regulations are in the state where you're doing business, because you're seeing a lot of cross the state line transactions going on out there. And but nobody wants to take the time to talk with an attorney because it might cost a little bit of money to get a more viable. Yeah, exactly. I always say investors are cheap, and by the way, I'm one of those too, and I am cheap. I get it, but I know when to ask the right questions.
But if they're trying to make money on a loan, on an earnest money, the money's gotten even tighter, right?
Oh,
now we're talking about much smaller amounts of money, you'd think.
Yeah, but one of the things, Andy, that a lot of investors do to try to persuade a seller to work with them as opposed to somebody else's, they put up a large amount of earnest money, $5,000, $10,000, $20,000. And I'll tell you, we do that sometimes on the right deal because it does show that, hey, we're legit, we're going to get that deal done. And the average investor on the street, they don't have those kind of dollars. So they turn to someone to do that. But it's just, again, no one has taken the time to look at that. So, of course, I see a lot of people out of Arizona coming here or transferees from other states coming here. And I wonder if they're bringing that concept with them, going, hey, we could do it in Arizona, therefore we must be able to do it in Texas. And of course,
I'm guessing that they're not even getting legal advice here in Arizona.
Yeah, they're not even asking.
I mean, if I had to, guess, but yeah, it's a problem. And that's why, when you're going across state lines, you have to be so careful in making sure that all the clauses are right and everything. We were talking to, and I don't think Texas or Arizona has them to the same degree, but on one of our shows, Bill Bronchick up in Colorado, and I brought up the fact that they have these foreclosure rescue laws up there that require very detailed language and rights of rescission, and it's a big deal if you violate those hefty penalties and fines, and you have to. You can't just, say, oh, a 3-day right of rescission, that's what you get. No, you have to identify exactly like the date and time that they have till they can, till it becomes a binding and enforceable contract. So you run up there and you start doing deals with just some standard contract you found off the internet or somebody provided to you, you're going to be in trouble.
Yeah. And, I have been on many podcasts with these transactional coordinators, trying to help them understand the business better and whatnot. And, one of the things that I heard through some very knowledgeable sources is that there's 23 states that have some form of foreclosure rescue laws out there. I couldn't tell you what all they are right now, but some not so intrusive, and some, it's criminal, if you do things of that nature. And so you got to be cautious how you do it. And the question becomes, is anybody actually looking into it or not? And so many investors, they just want to do deals. They think because everything works out great that there's no problem. And as we know, nothing's a problem until it becomes a problem. And then it becomes a really big problem sometimes.
Yeah. Well, the Colorado Attorney General has pursued investors for violating the foreclosure rescue laws, and the results weren't pretty for the investor, as you can imagine. So
there's
just something
there's
that-
criminal penalties to that law, aren't there?
Yeah, there can be. Now in Arizona, we have foreclosure rescue laws, but not to that degree. So our foreclosure rescue laws are more dealing with like loan modifications and payments that people are taking up front for loan mods and things like that. There's also federal law on that, but we don't have our law actually is very similar to Colorado and has a lot of the same language, except in Colorado, they take it a step further and they talk about an equity purchaser. So an equity purchaser of a loan in default or of a property in default where they're buying it subject to, that's when you have to do the disclosures. Arizona does not have the equity purchaser qualification or category. It just has like, I forget what they call them, but they're like consultants, loan consultants or, that type of thing that they're paid to help you, stop a foreclosure or negotiate a loan, more loan mod or those types of things. So we don't have it to that degree, but Colorado, Oregon, Washington, I believe have it, pretty significant, rescue laws. And default isn't, hey, it's in foreclosure. It's 30 days past due. Yep. That's it. So you could even think, oh, I'm going to do this subject to, and you're unaware of the fact that the, borrower hasn't paid their loan for 45 days. And all of a sudden now you're sideways of that law. So, you might as well just have the proper language in your contract, right from the start, if you're going to do a subject to transaction up there.
Right. I'll bring up, I got two more little quickie things, but the first one is these are things that just pop up daily, and I'm sure you guys see a lot of the same things, but, where we have guys who are, they're from Arizona, Nevada, where they're from, and they have their corporate entity there. Of course, they want to come out and do business in Texas or someplace else, and then they want to create this multi-tiered system of ownership, or through a trust or whatever it might be.
Yeah,
and they don't realize that when you start playing this game, it's like if you're going to start doing this and buying assets in a state, you've got to have somebody in that state who's a registered agent or a natural person who can be served with process appropriately. And I still find it incredulous that you talk to them and it's a blank stare. That they don't understand the basics, because somebody sold them something somewhere down the line on how to do all this funky stuff. I know we brought that up, I think last time or time before last, but it's just like, holy cow. And
well, once again, you brought up Arizona, and Arizona's the wild, wild west once again. So, but it's a bad move. I don't like it. We've had clients who have come to us after they've done it, but in Arizona, the law is that a foreign LLC can own real estate in Arizona without registering to do business in Arizona.
Yeah.
And that's fine. However, where things get, a little sideways and where people run into problems is if you have to go to court because there's a dispute regarding that property, or because let's say you have a tenant that you need to evict from that property. So you need to go into court and access our court system. Then our state laws say you have to register to do business to access our court system.
Wow.
And so where people get sideways, and I'm not a big fan, I don't know how you feel about it, but I'm not like a big anonymity guy. Like, oh, you need that Wyoming or Delaware LLC, and that's the premier protection or whatever. That's not asset protection. That's not the corporate veil. It's just anonymity, potentially a deterrent at most, But they go and they form the Wyoming LLC, and then they go and they own real estate in the name of that Wyoming LLC here in Arizona, and something goes wrong, and they're like, time to file. And they come see our law firm, come see Brian Locker, one of our partners. And Brian says, oh, it's a Wyoming LLC. Have you registered to do business in Arizona? No. Well, you're going to have to before we file this lawsuit. And they say, oh, okay, that's great. And so then, Elizabeth fills out the paperwork, gives it to him. Well, now what are you disclosing? We're not, we have no anonymity in Arizona. So you're disclosing the members, the managers, the whole thing. And they're like, well, we don't want to do that. It's like, well, do you want to file the lawsuit? Do you want to respond to the complaint? What do you want to do here? But this is what you have to do. And it's a real mess. So my recommendation is always and title companies feel better about it too. Even though I've had plenty of title companies insure, transactions to foreign LLCs without them registering. But my recommendation, whether you're doing business in Texas, Arizona, or otherwise, is because I just think it's easier to do it quick, is to have just a holding company. And then every state that you're going to do business in, form an LLC in that state owned by that holding company, and then put the property in that LLC. I mean,
isn't that easy? It's that easy. But somebody has been sold something somewhere, and how to do all this fancy stuff. I know Andy and I talked about this last time, in depth, and it's just like, they all think that they need this anonymity for all these. They've been sold this stuff, and it's like, guys, just if you do good business, you do it the right way, the great odds are no problem. And if we want to find you, we're going to find you.
Now, even lawyers.
Yeah, that's exactly right.
We're going to find you. Even lawyers play games, though, with statutory agents. One time I represented a client. He had a judgment against this judgment debtor. It was substantial, and he got wind that there was going to be he had a personal injury case, and there was going to be a personal injury settlement. So we waited and watched, and then we got wind that it's settled, and we had the idea that we were going to go garnish this lawyer's trust account, his PI lawyer's trust account, to try to basically seize, with the judgment, the settlement proceeds on this PI case. We served the garnishment on this law firm. And this person wasn't there to serve it. It was the managing partner of the law firm. So I called, and they're like, well, he's not here. And I said, well, where's the statutory agent? We have to be able to serve somebody. And they said, well, he's on a mission. We're like, a mission to where? And it was like to Guatemala or someplace like that. And I'm like, well, when is he coming back? They're like, well, his mission's done in like 3 years. He'll be back in 3 years. I'm like, you guys have to accept service. You can't just send your stat agent on a mission and not come back. But
that's interesting. I get that. I will say one last thing. So Andy, I'm gonna be talking to you here soon, since Sean's up there playing golf and piddling around in Wisconsin. So we are in the process of, and I may need a little help, I don't know, of opening our title offices in Arizona.
All right. Wow.
What that means, I don't know yet, but we're going to find out.
Yeah, that would be exciting. I don't know what that means either. The guy that knows is off up in Wisconsin playing golf.
I've represented a few title companies over the years. Andy did one recently too.
We've done that.
Helping them out with some stuff.
So.
But we're happy to help. That's exciting, Scott. Congrats.
We'll see how it goes, and we'll be in Arizona here soon. When I do, I'll reach out to you guys and give you a holler and come by and say, hey.
Yeah, that would be
absolutely.
Share some ideas there.
Yeah, that'd be awesome. Well, thanks for your time. We're at about an hour here. I know we lost Jeff to the reception. Hopefully we'll get him back the next time, but good discussion. As always, learned a lot. Thanks, guys.
Always fun. You guys have a great time. And Sean, when's our invite to Wisconsin? Free room and board, all that stuff, all those good things.
Let me know. I mean, it's low 80s, 70s in the afternoon, evenings. Come on up. Research it. Look up Sheboygan.
Will do. You boys have a great evening, guys.
All right, you too.
We'll see you.